Welcome to the first in our new series of remote family law seminars, just as we're entering this second period of lockdown. I'm Sian Smith and I'm here with Gemma Taylor QC, and we are joined today by Sharon Batchu, Sherma Polidor and Patricia Berry-Welf. They will be discussing parental alienation. This is part 2 of their talk. You can find part 1 if you missed it on our Chambers YouTube channel. And this part of their talk deals with issues arising after the fact-finding. Sharon is a barrister practicing at 42 Bedford Row, specialising in all areas of child protection. Sherma is a family law solicitor at Venters, with offices in London and Reigate. Sherma deals with all aspects of family law with a particular interest in matters relating to children, whether private or public proceedings. She's accredited by the Law Society for work relating to child abduction and wardship and private children matters. And they're joined by Patricia Berry-Welf, who is the founder of Co-Parenting Matters, child and family therapy consultant, a specialist systemic family psychotherapist, play therapist, and family mediator, independent social worker, and expert witness. After that talk, which will be about 30 minutes or so, we will have time for some questions. If you do have any questions that you'd like to put to any of our panelists, please feel free to use the Q&A function, which is down the bottom of the screen. Gemma and I will do our best to put some, if not all of your questions to our panelists if we have time. Just a reminder that the webinar is being recorded and it will be available via our Chambers YouTube channel after today. So that's it from me, and I'm going to hand over to Sharon, who's going to get us started with tonight's talk. Thank you, Sharon.
Thank you, Sian. I'll just wait for the other two to turn their videos on and unmute themselves. Hi, Sherma.
You're right.
Thank you. Welcome back, everybody. Part 2 of parental alienation. During the first part of this topic, we looked at parental alienation and the need for an early fact-finding. Today's discussion looks at webinar. And it became apparent very quickly to us the discord between the formal court process and the therapeutic work that experts like Trish bring to this area. I hope that you will find this discussion helpful in trying to amalgamate the two while helping the court and parents in meeting the welfare of their children. For ease of reference, last time we referred to the recent authority of Ries and the judgment of Lord Justice Jackson. I would urge you once again, if you haven't already read it, or if you do pick up a matter that involves parental alienation or high conflict, please go and read it, especially paragraphs 7 to 13. It makes very important reading when considering this area within the child protection arena. So turning to Sherma, first of all, Sherma, we've had a fact finding. The judge has either made findings against your client or upheld the findings that your client was seeking against the other parent, or possibly made no findings. Those are just some of the possible options. There are others. What then, from your point of view?
Well, I think the most important thing, firstly, as any kind of legal representative, caseworker, paralegal, legal exec, solicitor, is just reiterating to your client the advice you would have given them before a fact finding took place, which is that essentially whatever the judge says in the fact finding judgment is the baseline upon which everyone will start. And that's very important to reiterate to your clients, because obviously if the findings made don't correspond with what your client wants, firstly, they're going to be very upset, but they obviously will keep repeating the same allegations, which is not going to help them move forward. The other thing that I will say is obviously fact findings, like other decisions, can be appealed, but you have to be very careful. And as legal representatives, we know how difficult it is to appeal a fact finding. If a fact finding is not appealed, then, as I said, the decision of the judge forms a factual matrix, and we're going to use that in order for the therapeutic work to start. What I will say is another thing that's very important is making sure that the parties have time to reflect on the judgment that has been made. And the best way to possibly do that is especially if you're the client who's had findings made against you, is to have a statement, is for a direction for a statement to be put in place so that the client can say what it is that they think following the judgment that's been made.
Can I ask you, Sherman, you talk about statements, reflecting upon the position of the parties once a judgment and findings are made. Why is that so important?
Well, I think one of the main reasons why it's important is because, as I said, the judge has made a decision, and we have now got a factual matrix upon which people like Trish or other experts are going to work with this family. And we need, especially the person who's had findings made against them, we need them to have time to reflect on the findings, and then to actually not only let the court know, but let everyone, whether it's the person who's going to be working with them, the expert who's going to be working with the family, and the other side, know that they have reflected on what's been said and how they actually feel about that, because that also gives the people like Trish a basis to understand where we go from there. If you don't have that, then everyone's working on the assumption that the person's kind of understood and agrees with what's been said, and that may not necessarily be the case. They may agree with a couple points of it, but may not agree with all of it. The other thing is, it's also really important for there to be a period of time for everyone to look at the judgment, so that a decision can be made about the Part 25 applications that are made and which experts are going to be used. So a decision has to be made whether you bring in someone who is, say, for example, a specialist psychologist to do a viability assessment on this family, or whether you have someone like Trish who does a whole ream of work to help these families. And it's basically trying to make sure that the application you make to the court is the right application and the right people are helping this family. The other thing to really remember is this is not a quick fix. Just because the finding has been made, say, for example, of parental alienation, it doesn't necessarily mean, oh, yes, that's it, it's all done, everything's going to go back to normal. No, there's a lot of work that needs to be unraveled. And this is not just for a parent who has been accused of alienation or a finding's been made that they have alienated a child. It's also for the parent who has been alienated, because no matter what's happened, there is a lot that needs to be done with this family, with everyone in this family, for them to be able to do therapeutic work. As an example, if you are a dad who's been alienated from your child, you may not have seen your child since they were in primary school, and they're now in secondary school. That person is no longer the little child that you remember. They're not 10 anymore. They may be 15 and have a moustache and be 6 foot tall. And they are their own person and have their own views and thoughts. And you weren't there for any of that. And it's important that everyone works together to re-establish that relationship.
Thank you, Sherma. You and I know, and those of us that deal with this area of the law, know that once an expert's been instructed, proceedings usually take on a very different tack, don't they? It's more about moving away from the slightly adversarial approach that fact finders bring, and looking, as you say, at unravelling the problems now that we've got that factual matrix to be able to work from. And of course, Trish, that's when you become involved, and your role is so very different to ours. And in the very helpful discussions that we've had, there are a number of points that I just wanted to raise for discussion with you. And I'm going to ask them as a series of questions, because I think that may be helpful for those that are taking part today. So first of all, I'm a lawyer who's representing an alienating parent. What strategies do I need to adopt, or should I consider adopting, to help my client when we're looking at protecting a child from further emotional harm and abuse?
I think it's really important that you support the client to accept the judgment, and the client is going to have various feelings about that judgment. And one of the issues is going to be how to help the client to regulate their own emotions, how to actually be able to do that in a way that they have got the capacity to hear what they need to do next. What we do know about dysregulated conditions is that when people are stressed or upset or anxious, their hearing is 75 to 80% down. So they're not really hearing what's being said. So it might take a little bit of time for you to work with your client to get them to a place where they've got a platform they can actually hear what you're saying. I think it's really helpful to suggest to the client that, you know, we're now moving away from blaming the other parent, and we're going to try and move away from the high conflict, because high conflict is where this starts. And it's important that they maybe start to think about their part in this process. What is their contribution to this process? What do they think that they could do in relation to improving the emotional health and well-being of their child? And how would they envisage working with the other co-parent? I think it's important that the parent is supported with their disappointment. And they might be angry, they might be disappointed, they might have a range of feelings, they might have invested a lot in the case. They might be experiencing grief and loss at the fact that they've lost the case. But it's always important, I think, to point out to parents that actually there are no winners. There are only losers, and the children are the main losers in this. So it's something about changing the language, helping your client to really regroup and change the language into one of not blaming and shaming and naming and trying to take it away from the right and the wrongs, because each parent is right and each parent is wrong. And the child needs both parents, because the child is a part of both parents. So if the parents continue to hurt each other, they continue to hurt that part of the child that's a part of the parent. So in those simplistic ways, your task is cut out for you, I guess, to get them to a place where they can entertain the idea of, you know, engaging in a therapeutic process that really isn't about taking a side with that parent or the other parent. It's about remaining neutral and supporting both parents in their relationship with their child, as opposed to the paradigm they've been working with before, which is usually very much focused on the parent-child relationship. So the goals are to try and get the parent to consider moving towards the development of a co-parenting relationship, where the child is the child in this co-parenting dyad, as opposed to the decision maker about the contact.
Thank you, Trish. That's really helpful. Interesting. We've touched on high conflict, and within these cases, can I just get you very simply to just explain the difference between high conflict and parental alienation, and whether they interact?
Yeah. Okay. So simply, there's a lot could be said about this subject area. I see Sherma smiling there. I think high conflict, we can think about high conflict as a pattern of kind of all or nothing, difficulties regulating emotions, extreme bizarre behavior, sometimes a preoccupation with blaming others for everything, and not taking responsibility for yourself and your own contribution to a process. Of course, we all have a contribution to a process, even if you might not like to admit it. So a parent in high conflict can engage in bullying or accusations or humiliation, and engage in adversarial behaviors. And so rather than reducing the conflict, this actually keeps and maintains a pattern of conflict going and doesn't resolve it. The idea that people are good and bad is a very simplistic way of thinking about the human condition, because of course it leaves out the grey area. and it leaves out our own vulnerabilities and failings, and the ways in which we might not be so great. So there's something about trying to get them to get to a place where they're not in that polarized kind of way of thinking. But there are different high conflict personalities. There's the narcissistic high conflict personality, which is characterized by an underlying fear of humiliation or feeling inadequate or feeling shamed, which is a core dynamic in every relationship, but has implications in this particular context for that parent, because in a way they have an emotional disability in terms of being able to engage in the process. Borderline high conflict personality, they can often be clingy and very demanding because they fear being abandoned. And unfortunately, when they're clinging and demanding, they generally are then rejected and abandoned. So there's something about a repetition to repeat something that they know. An antisocial conflict personality type is when someone wants to dominate someone else because they don't like to be dominated. But again, this can result in driving the person away. And if someone is got a paranoid conflict personality, they fear about being betrayed. They have a fear of being betrayed. They have a fear of being let down by somebody. And histrionic conflict personality consists of people who criticize and target other people, but they don't look at themselves at all. So I think that these different kinds of high conflict over time do interact with parental alienation, because the child who's exposed to that, the war between their parents, will hold a loyalty conflict for each parent for a long period of time, as long as they can. And then eventually they surrender that because it's a very uncomfortable position to be in. And they choose two ways out of this. They either become neutral and unaffected and not loyal, but just perform and comply, or they align with one parent against the other parent. And the child is an innocent victim in this. The child is just trying to find a strategy to survive, a psychological strategy, not to feel the discomfort of cognitive dissonance when they are holding two contradictory and incompatible feelings about both of their parents, who they are attached to and they are a part of. And it's not possible for them to do it.
Can I just ask you something just very quickly on that point, Trish? I imagine that, am I right in thinking that children will display that or their strategies in a whole range of different ways?
Yeah. So they might display it by acting out behaviors. They might display it through chronic stress. They might display it by developing attachment anxieties or separation anxieties, headaches, stomach aches, cramps, might somatize it. They might self-harm. They might have suicidal ideation. There are children who've had suicidal ideation. And they're using self-harm sometimes as a means to manage it, but the self-harm can be seen as the problem. And obviously anybody who's responsible would want to assess that and make sure that it wasn't a real risk. You know, I think it's very difficult for children because this isn't their war. It's been their parents' war, and they're exposed to this for long periods of time in a lot of cases that I work with. And parts of their childhood have been missed with one or other parent. And in a way, if they idealize and split and psychologically split, which is the other mechanism, splitting the world into black and white, just like maybe one of their parents has split the world into black and white, or both of the parents might have done this, then they haven't got the capacity to feel ambivalent. So their capacity to feel ambivalent or doubtful about the validity of how vehemently strong they feel against another parent is missing, because they can't resolve what is their parents' issue to resolve. Yeah. They are the ways, I think, in which children are affected by this.
Can you help us, Trish, on how traditional therapy, as us as lawyers understand it, works in these sorts of cases? Does it?
Well, the international research is saying it doesn't work. Traditional therapies don't work. Traditional therapies have their place. I think you've frozen on the screen, Sharon. But what we need to be looking at is working with the family system and the family dynamics in that system that are dysfunctional, that the child has internalized as a working model of relationships. And the child thinks that that's the normal way. When we're children, we're in a family. We don't know any other family. That's the family we've been brought up in. So it becomes the norm for the child. And I think that parental alienation, in the way that it's played out for children, they don't really have a real relationship with either parent, because the idealized relationship isn't a real relationship. And the relationship with the parent they're rejecting isn't a relationship either. So there's no kind of balance for them in relation to finding a kind of way in which they feel comfortable in their own identity and their own skin, with their maternal and paternal kind of sides of who they are. So in terms of answering the question about the traditional therapies versus the specialized therapy, a traditional therapy will validate, it's a contract between a client and a psychotherapist or a psychologist or a counselor, which validates, it's a subjective relationship, which validates the client's experience. So there'll be many cases I'm working with where one of the parents may be seeing a traditional therapist, probably an excellent traditional therapist. However, sometimes when I talk to these therapists, they are doing harm in a way that they don't realize, because they are validating one part of the family narrative. So the parent who maybe is alienating the child is not being supported to look at the whole family system as the treatment modality. The treatment needs to be done with the whole family system, not with one person within that system. So normally it's quite important that whoever is delivering this sort of an intervention, it doesn't mean that they can't continue to see a therapist they might have been seeing, but I always ask for a professional consultation with that therapist, just so we're not working in oppositional ways to each other. Otherwise, it's detrimental to the child, and the child isn't afforded protection. Equally, a lot of children get referred to CAMHS, or they get referred for anxiety or depression. And actually the root cause of the problem is the state of play in the family system and the family dynamics that they have internalized. So the child feels overburdened with trying to resolve something that they actually can't resolve. It's not actually their problem. So it is their problem in the sense that they are psychologically and emotionally deeply affected by it. But I would always make a safe space for the child, but would not make the child the center of the intervention till much later on, when there had been enough work done with the co-parents to get them to move towards a co-parenting alliance where they can develop a family narrative, each taking responsibility for their part in this process. That takes a bit of time.
Right, lots to think about there. This is a slightly different question to one I asked you earlier. How do we, again, as lawyers, assist with supporting parents after a fact finding in dealing with their feelings so that they can enter some systemic family psychotherapy or whatever other work is recommended?
Well, I think it's important that you have access to the research in terms of the long-term impacts on children of parental alienation. Amy Baker is a very good source. She's done a retrospective study of adults who were children who suffered parental alienation as children. And the findings are clear in relation to depression, relationship problems, substance misuse, suicidal ideation, and lots of other differential diagnosis on top of that. I think there's also the longer term vision here. I'm a bit older than some of the panelists. I'm a grandmother, so at the end of the day, these parents can be asked to say, when you're walking your son or your daughter down the aisle when they're getting married, what would you like them to say about your separation and your divorce and how you handled it? will you be walking your son or daughter down the aisle if you don't resolve these difficulties? What about if your son and daughter has a child and you become a grandparent? You know, so there's a much longer way to go beyond the ending of a court case in terms of people's lives and in terms of the intergenerational influences that could potentially move on to adult children who become adults, and then they have their own children. And, you know, so there is a lot to consider in terms of them taking a less of a short-term view and really trying to appeal to that part of their nature and getting them to sort of stand back and reflect and think about that and what they would actually like to say.
Yeah. How does a court order assist? Is it an essential component in moving towards co-parenting, moving the parents towards their desired goals?
I don't think it's possible to work with parental alienation cases without a court order and without a tight time frame on that court order and without the support of the court. The reality is that no matter how brilliant a therapist is or how well intended, they have limited ability to keep the parent who may not be that motivated engaged in the process. So the process that I offer is a challenging process. It's a supportive process, but it's also a challenging process because I'm saying to parents, you know, your first job is you've got parental responsibilities to support each other as mother and as father of your children. And you have to each do that for the other parent. Now, if somebody doesn't like what I say, then they say, well, I'm not doing this anymore. I don't have to stay. You know, I'm not going back there. So I go, well, that is obviously your choice. So when I've had consent orders, they've worked for a certain period of time. But the reality is that then it gets delayed again, and time is the enemy for these children. The longer it goes on, the harder it is to repair and restore and offer a facilitated child parent session to the parent who's been alienated. And you have to work really, really closely with the parent who's alienating. They might not be aware of the ways in which they're doing that. They might be unconsciously alienating. However, we all know that that doesn't in a way affect our consideration of the welfare concerns for the child, because it's the process that and how it's affecting the child that we need to bear in mind. So I would say a court order and the oversight of the court, because otherwise the process goes on longer. And, you know, the potential then is that that relationship is threatened. And some parents sadly don't get their relationships back. I would suggest a reporting time of 12 weeks, but not, you don't have, nobody in the court wants to read the ins and outs of everything that was said. They don't have the time. But, you know, the engagement in the sessions, the formulation, the focus in the sessions, who was seen when, what dates, for how long, what the progress was, what the impediments to progress are, what the recommendations are moving forward, so that the parents know that they are also being supported by a system around the parents, as opposed to it being down to the process or the therapist. So very often I work with children, and when the process starts to become successful, the children don't like the therapist. Now that means the work's been successful, and I'll explain that. They don't like the therapist because up until then, they've been the decision makers about the contact. So I will say, well, I'm not the decision maker about, the judge is the decision maker, but I'm here to try and make the process better for mommy and daddy and for you. And so because they've been then displaced from possibly a parentified position with the parent who's alienated, they don't like the therapist. And that can be taken the wrong way. Or a parent who doesn't like what I'm saying might say, well, she's useless. Well, you know, yeah, maybe. But I just think it's important to check these things out, and also not to report things out of context of the sessions, because there's more going on than one sentence that was said, and there'll be a context before and then a context afterwards. And sometimes parents who want to prove a point or go back to a solicitor, due respect to my colleagues here, they will take it out of context, and then that becomes destabilized because, to be fair, the solicitors don't know actually what I'm doing. So it would be good that we could have some integration of, you know, the clinical room and the courtroom in terms of working together in a kind of much more unified way.
Yeah, definitely.
On behalf of the children.
Well, I think that brings me to the question then I've got for Sherma. How do we then, Sherma, meet the need for both the formal court process and the work that Trish does and all the concepts that we've talked about today, and there are many more that we haven't even touched on, in order to be able to represent our clients as effectively as we can?
I think, as I said before, it's important for clients to appreciate that there's no quick fix to this. It took a long time for that child or your children to be in the situation that they are in now. And it doesn't mean that within 2 weeks, or as soon as a judgment has been made of alienation and you have a few sessions, that everything's going to be back to normal. That's not what is going to happen. There'll probably be a couple times when it's 3 steps forward and 1 step back. But it's kind of trusting the process and persevering with it, and making sure that you have an expert that knows what they're doing, like Trish, and making sure that you are touching base with your client, but you're not putting too much of your own input into it. The other thing that I think is really important, especially as legal representatives who are being paid to represent clients, we are not yes people. That's not our job. Our job is to take instructions and provide advice. If you are just agreeing with what your client is saying, then essentially you are doing more harm than good to this whole situation and this family dynamic. Because once the final order's made, you are no longer there, and this family still has to continue as best they can. So if your job is to take instructions and give advice, part of that advice is to appreciate the consequences and let your client know of the consequences of what their actions will be doing. So for example, if your client turns around and says, I don't want to do therapy anymore because they're upset that Trish may have misunderstood something, or they believed it to be misunderstood, and rather than dealing with it with Trish and trying to have a discussion about it, they want to go to court and no longer have the expert involved. Actually, in terms of the long-term process, that's just causing more delay to the situation. Your children are not getting the assistance that they need. You are not getting the assistance that you need, and neither is the other party. And actually, at the end of the day, that's not helping anyone. So as legal representatives, we need to fully appreciate, even if you are getting paid, that you need to think about looking at this family as a whole, and the actions and consequences of what your client does.
Thanks. What became very apparent to us as we were talking to Trish previously was the need for education, the need for information, certainly for the legal profession. Whether we're barristers, whether we're solicitors, whatever input we have, to be able to understand the wider picture and what's involved. And I hope that today we've touched on some of those. Trish, I think there is a document available, isn't there, which touches on definitions of some of the concepts that we've talked about today. And if people were to get in contact with us, we would be able to send that out, which provides a bit more information. But of course, everybody is welcome to give one of us drop us an email to see if we can help in terms of broadening our education and trying to understand, as Trish says, some integration between us. It can only help parents, but especially those children out there who are suffering so much. So thank you. Thank you very much.
Thank you. I'm Gemma Taylor, for those that don't recognise me. Thank you very much to Trish, Sherma and Sharon for a really, really informative talk. I really love the potted summary of the rather challenging personalities, Trish, that we will all recognise. That was really helpful. It's also given us really helpful pointers and insight into this incredibly complex area. I'm so sorry that we have limited the time that you've been allowed to try and squeeze all of this amazing and informative advice into a short seminar. There is, though, time for some questions. So I know that some of you have already started sending questions, and we're going to put those to our panelists. But first, I'm just going to ask Sherma a question, if I may. One of the matters that Sharon asked you about at the outset, Sherma, is really next steps following a fact-finding hearing. And the advice appears to be, take stock, get a statement, give clear, impartial advice, get an expert overview, and then look at the right therapy. I'm assuming that all of that needs court oversight for it to succeed. But in addition to court oversight, does there have to be shared responsibility between the parents for the resolution of parental alienation in your experience?
Yes, the short answer, yes. But to elaborate a little more, as I said before, if you are a parent who has alienated a child or been alleged to alienate a child, you need to work with the other parent, as difficult as it may be. And if you're a parent who hasn't seen your child for a long time because your child's been alienated, you also need to work with the other parent, because technically they are the resident parent, and both of you need to work together in order for this to work. It's not going to work if you don't co-parent. And this is not just co-parenting now, and just because there is court oversight. This is co-parenting for the rest of your child's life. Essentially, like Trish said, it doesn't stop when your child reaches 18. What happens if they want to go to uni and you want to drive them up there? Are you both going to go? When they get married, who's going to walk them down the aisle? Like, both of you need to be able to do this, and it will only work if both parents are dedicated and involved to basically loving their children more than they hate each other.
Thank you.
Thank you. I'm going to take the next question, I think. So I think this one for Trish, and it's just really to understand whether there are theoretical principles that are underpinning your clinical intervention that you provide for families in this situation.
Yeah, so I adopt a sort of multi-modality approach, and that's really because of my training and my background and my experience, because I did clinical social work for a long time, worked in CAMS for a long time, worked in adult mental health for a long time, and worked as a psychotherapist for a long time. So I've integrated a lot of different aspects of that. So it would include observations of the dynamics of attachment, for example, between a child and each parent, because you can tell a lot based on infant observation studies about the emotional development of the child, as integrating that as part of it. There would be psychodynamic aspects to this, i.e. mirroring back to the parents in the co-parenting session, how they are responding to each other and the impacts that has on the child. They may be genuinely not aware of that, but that has to be paced and timed in a way that they're ready to hear that. So it's useless doing premature interpretations, because all you will do is drive parents into a corner and drive them away. So you have to gain the trust of the parents. You have to create a safe space for them. They have to experience you as neutral and not taking a side. And in the initial intervention, it's really interesting. I meet both parents separately and then the parents together. And it's almost like they feel like they're coming into a hearing, a court hearing, and that I'm going to find favor, one is right or one is wrong. And so I have to kind of change the language. So I take the language of blame and right and wrong and some of the court language out of it to try and retrain them to think about this as a human condition state that is an opportunity now to resolve it and to really stem the tide of the conflict going on. There may be psychoanalytic insights, there'll certainly be systemic insights, there'll be solution-focused interventions, there'll be conflict resolution strategies, there'll be testing of that. I'll be looking at their own attachment histories, because we all come to parenting because we had parents. That's our own model. That's everybody's model. Is their first model was their own parents. So when these parents give birth to that child, there's not just two parents there's 6 parents. There's each parent and the parent, so the grandparents, and there's the other parent and the other 2 parents. And we call this the ghost in the nursery. And I think that sometimes we forget that most parents want to do their best for their children. It's just that they haven't had the modeling, or they haven't been able to resolve some of their own inner conflicts, and they bring this into their parenting role. So one of the other interventions as part of the co-parenting work is therapeutic parenting support sessions. So if something comes up in a session in the co-parenting, I won't address it for that parent then to feel that they've been pulled up or shamed in some way. I have a separate session with them where I will look at how they can attune better to their child, or if their parenting is punitive or reactive, I will help them with mentalization, reflective practice, and I will model that for them. So there's various bits that they are practicing and developing. I call it developing your emotional muscle to do it in a different way. And we can test it. And I use at the center of this all the time, when things are difficult in the sessions, I will say, well, now I am your 10-year-old son. And you know what that has made me feel like as a 10-year-old. And I will reflect back to the parents how hurtful it is for the child. So the child might feel anxious, apprehensive, or fearful. And that's where some of these feelings are coming from in the child.
Thank you.
So there's
really
lots of different aspects to it.
Sorry. Thank you.
Trish, I know that we've in fact been inundated with questions about what therapy you'd recommend, etc. But as I said, we've had very limited time. So I hope that that's answered many of the questions that are aimed at that element of this difficult and complex situation. But on a practical note, Sherma, funding for the work that's required, because step 1 is the fact find. And as I've said, then the statement, then the work and expert input. Do you have any pointers for those who are representing parents or even local authorities in these cases?
This is always the sad question, because unfortunately, people like Trish, because as you can tell, Trish, this is her baby. She spends a lot of time dealing with high conflict cases, parental alienation. And so people who are doing this kind of work, they are unfortunately not the cheapest people to have. Not in a horrible way, Trish, but they're not. They're not like, because what is it, legal aid rates for an independent social worker is £33. A lot of those independent social workers don't deal with these kind of cases. A lot of them deal with care cases where the abuse is quite overt, and this is not as overt. And so in terms of funding, there is a difficulty. If these are care proceedings or a local authority is involved, unfortunately, the local authority does have to step up because the legal aid agency is not going to assist. And the situation is the local authority are unlikely, with their social work team, no offense to their social workers, are unlikely to have the kind of experience that is needed in order to assist these families. So if you are lucky enough to have a local authority involved, they do need to open up the checkbook and assist. If you don't have a local authority involved and it's just 2 parents and there's legal aid, you are going to be in serious difficulties. And again, it's prior authority applications. And hopefully one day the legal aid agency will realise the seriousness of this, like they did with doing sexual abuse risk assessments, because they had changed the their prior authority applications for those. And so you can get experts who deal with those kind of risk assessments who are outside the normal LAA scope. So fingers crossed it will hopefully happen for these kind of cases as well.
Sherma, then is the reality, and I don't want to trespass too much on part 1, but is the reality that for this to really be followed through properly, these cases have to be recognised as cases that represent very significant harm to children if action isn't taken? So local authorities should be invited to intervene, and that's the way forward.
Local authorities not only should be invited to intervene, but they need to take these things seriously. And I appreciate that this kind of abuse probably doesn't even touch their radar, because these children are doing well in school and they're doing okay with the parent that they're living with, and they're doing all their extracurricular activities and everything else is going okay. But clearly something's amiss in their life if they're not seeing the other parent for actually no real reason. I'm not talking about safeguarding reasons. And so what needs to happen is local authorities, all local authorities, need to be getting training. They need to be getting training from specialist people like Trish, or people who do such work, so that they can understand the nuances of these cases and the fact that they are very serious. Because I'm getting judgments in cases where they are saying that threshold has been crossed and local authorities are not doing anything. And that is very, very serious. And it shouldn't have to take a judgment, or it shouldn't have to take a court repeatedly making orders to get a local authority involved.
I've certainly cases recently where judges have ordered a Section 37 report with very clear, specific questions to the local authority to answer within that report, including whether or not they're going to take proceedings and what their views are in relation to significant harm to these children.
And just another point, if there anyone from a local authority who is on this webinar, whether you're a social worker or a local authority solicitor, what I suggest, if a case like this comes your way, make sure that you are reading the bundle and the judgment that comes to you, because it's come to you for a reason. People are not sending these to local authorities on a whim. These people genuinely need help, and there isn't anywhere else they may be able to get it.
Can I just make one last point to balance this on the local authorities, please? So I've been instructed, so I've worked with lots of local authorities, and I totally agree with what you're saying as well. Some local authorities won't fund it, even with prior agreement. And I don't want to mention the various local authorities because I know the ones, but then I am funded by other local authorities who have a great awareness of this and have some fantastic social workers in them. And they're the ones who will fund legal aid cases for me to do the work. So I just wanted to kind of bring that balance into it. It's not set in stone, but it can feel like you're pushing boulders uphill when you get no's all the time. And I understand that too. You know, and I have been in, as you know, I have worked in cases where that's happened as well.
Yeah.
We're going to have to wrap it up there. I think the final message is educate yourselves, everyone, and be tenacious, which is what we're all good at. Tenacious on behalf of the children and the clients in particular. Thank you, all of you who've sent questions in. We've had repeat requests for all of the research, citations, etc. All of that will be available on the website, I hope. I can only repeat my gratitude for our wonderful panelists and presenter Sharon for taking the time to present this really helpful talk. It will be on the YouTube, but I mustn't, I'd be failing in my duties as co-presenter if I didn't tell you about our fascinating next talk in our lockdown series, which is on the 17th of November. It's presented by George Butler and Dr. Ben Lasky, and it's about complex post-traumatic stress disorder and the family court, impact, intervention, and implications. So thank you very much for joining us, and hopefully see you in a couple of weeks. Good evening.